Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today, for part two, we have back Sharat Sasidharan, and who
Yes.
is partner and director of consulting wing at Khurana and Khurana in New Delhi, India. Welcome back, Sharat.
Thank you, Mike. Thank you so much for having me again.
Uh, okay, today, last time we talked about the process of the patent prosecution process in India and the differences with the U.S. Process. Let's talk about the benefits. What are the benefits do you get as far as enforce anything you want to say? What are the benefits?
Well, to start with, India is one of the largest, markets for pharmaceutical innovations, electronics, consumer electronics, software, automotive, renewable energy technologies. So I would say from a market standpoint, any of these domains, I think it's a hot jurisdiction and people should file patents in India. The second most compelling reason or benefit is it is fairly inexpensive as compared to very inexpensive by many times, I would say, as compared to US and Europe. The third benefit is the judiciary is pretty open and pro innovation. That means you can rest assured that you have a great invention and it is high on threshold. It would be the judge would always look at the innovation and you can get favorable, decisions, and enforceability therefore is possible. Unlike in some other jurisdictions, it may be a challenge. So all in all, I would say fairly inexpensive, largest market, and judiciary that is delinked from the government or the parliament means it has its own independent view of how innovations have to be fostered. It's a great jurisdiction to go for.
And can you get injunctions? Which I know in the
Yeah,
United States,
so
a lot of times it's difficult to get injunctions.
enforcement mechanism typically is through civil courts. Patent infringement is a civil dispute, and we have high courts, primarily high courts that have an IP division in Delhi, Mumbai, Madras, and Kolkata. So there is no specialized court for IP, although a lot of reforms have happened, and at least there is one court now that takes only IP matters into consideration. But still, we have a lot of matters pending. So, due to a lot of pendency and slow movement of cases, as you rightly mentioned, interim injunction is one of the most sought after remedies. Then we have permanent injunction, damages, accounts of profit, and then, of course, the seizure and destruction of goods that are infringing. So these are the remedies available. The fastest and the most inexpensive one is the interim relief, which probably takes, let's say, about, I don't know, 1.5, 2 years for a standard telecom case, let's say.
Ooh, like that.
I know, yeah, yeah. I mean, it is much better than what it used to be honest. And with lot of reforms and talks in place, a lot of policy initiatives, it would come down significantly. But interim injunction, once that is awarded, then there is a lot of scope. 95% of the cases are solved outside the court and it is settled.
What about damages? I know in some countries, sure, you can get a judgment, but then the damages aren't even worth the cost. Can you get a decent amount of damages? I mean, in the United States,
Yes.
we love to sue, we love big damages.
No, you can get a decent amount of damages, but I think the burden is higher as compared to other jurisdictions, and you the evidence has to be substantive, is what I say. And if you can show that there is an irreparable harm and there is a prima facie case of infringement, and there is, of course, a willful and innocent infringement, that kind of also makes a difference on the quantum of damage. But if you have had served the notice of cease and desist, and if you have been diligent, you meaning the patentee is diligent in informing the potential infringer about the rights that are being infringed, and you pursue it right from the beginning, then the damages can be pretty higher as compared to where it is, let's say, innocent or There would be damages. Ignorance of law is not an excuse, but there might be a little reduction of the amount. But damages are there. I have seen significant damages in telecom cases, majorly. Telecom space is heavily litigious, I would say, in India, and the next one would be pharma domain. But I think some of the biggest damages have been awarded in the telecom space, 3G, 5G, 4G inventions.
The foreign companies, they get an equal shake. There's not the hometown prejudice.
Not at all. And that is actually one of the reasons I mentioned earlier about why India should be on the list of
Okay.
jurisdictions. The judiciary is independent and they're not under the influence of the current government, one. And two, we see a lot of judgments in the favor of foreign applicants. And so there is no bias as such against any foreign entity. Three, pharmaceutical inventions particularly face the brunt because of other reasons like non-reasonable pricing not being made available to public at reasonable cost and in timelines. So for those reasons, there may be a policy related issue and not specifically a bias against a foreign entity, but I would say it is very fair and encouraging for the applicants elsewhere.
Okay, sounds good. Companies, they don't love the prospect of litigation. They don't love coming into a country and, okay, how can I sue? Is there a robust licensing and brokering of intellectual property over there and startups and, I'll say more on the transactional side and the business side
Mhm.
versus the litigation side? Is there an active culture there?
No, I would say the litigation side is far better developed and robust mechanism, whatever it is, as compared to the transaction side of things. There are no licensing entities or brokers that kind of are engaged in these commercialization activities. Uh, it is a gap and it is something that has to be developed as a central body or even in every corporate. There is no special initiative or drive for licensing particularly. In other words, I don't see a lot of licensing revenues or patents being licensed at amazing in amazing deals. I don't see that happening a lot in India as much as it happens in the US.
So mostly, if you're coming into India, you're the one who's going to be manufacturing, or you're going to have a local manufacturer, but you're not going to be licensing to third parties generally.
Yeah, yeah. So that way, so the supply chain and the manufacturer, the vendor scouting, that part is pretty robust.
Right.
And that is not particularly referred to as a licensing engagement.
Yeah.
It is more to do with setting up your plant in India, you secure a patent, and just for the sake of sanity, you license the technology to the vendor and they make it, and then you kind of make the product or service available. Yes. But it is licensing is not the primary objective. Mostly they just want to be present in the market and figure out the raw material, supply chain expertise, and all the legal, barricades have to be crossed, compliance, and then you set it up and then make it available.
What about it? Just came to my mind. What about like local ownership? Does an Indian company have to have 50% ownership or something? Or are there any particular ownership rules that someone coming into India should be aware of?
Yeah. So the ownership can be. I mean, the foreign lot of foreign entities have offices in India,
Hmm.
and the India entity. So it is not any sort of collaboration. It's a subsidy or an enterprise in India that is registered as a corporate in India. So the standard rules of corporate law apply to an Indian entity, although it can be owned by, but there have to be assets that are managed by an Indian presence, and there has to be a director of sorts. So all those incorporation of companies, the whatever is required have to be followed. But I think it is just the shell requirement and mostly the control mechanism sits always in the headquarters, and the India CEO, so to speak, or the managing director, who typically is hired from India, or sometimes there are also implants from various countries. Samsung has it from, Korea, and Panasonic from Japan, for example. But mostly it is Indian governance, Indian law, and Indian corporate law that is applicable. There has to be X number of directors on the board, Indian directors versus, the foreign directors. So that ratio has to be there. So although it might look like it is 51%, owned by Indian entities or
Okay,
sub-entities or individuals, it is still probably managed pretty much by the foreign entity.
that's all very interesting. About time flies, about ready to wrap
Sure.
things up. There any other
Mhm.
things that you think some company or entity wanting to do business in India and export their technology over there?
Yes, so there is something called a working statement requirement that was a problem, earlier for a lot of corporations. So once you get a patent granted, you have to had to initially submit every year a working statement on what did you do to make it available to public or reduce it to
Uh,
practice. So recent changes and in patent law and rules have now relaxed the requirement. So the requirement is not frequent, once in 3 years, and it is like per patent, the working statement has to be submitted, not per product. And number three, you don't have to submit the numbers on the quantities of the product manufactured and the sales. And even a a document that shows the initiative of setting things up or in the process of setting up can be used as a working statement rather than actual reduction to practice. So a lot of companies did not want to file in India because they did not want to manufacture. It was just to patent and keep it like that. So compulsory licensing is something people have to watch out for. So if you do not want to manufacture, someone else will apply for compulsory licensing, and the patent office may award that license to the manufacturer because you did not do it. One, two, you did not make it available to public at a reasonable price. Three, in a reasonable time frame, especially the drugs and the pharma, innovations. So I think that is something I would want to call out.
yeah.
Lastly, yeah, there's a lot of SEP, standard essential patents, that are being filed. Telecom is the largest, the booming industry in India with a lot of subscribers, the largest number of subscribers in the world in a single country. So that space is something to watch out for. So if there is a telecom innovation, it should be filed definitely in India. The examination is robust, a lot of litigation has happened, standard essential patent has garnered a lot of attention. So that is something to watch out for pharma and telecom.
So does the court or the Indian Patent Office set the reasonable royalty? How is that determined?
No, so typically it is driven by the court. There is no standard setting organization or a governing body to talk about FRAND, terms, fair and reasonable and non-discriminative terms for licensing. But it is mostly driven by either arbitration, mediation. People solve it with a lot of discussions, or they approach the court, and that is where it is called out. But I think there is a lot of work going on in that part as well. We see a lot of organizations coming together to put together a consortium of sorts for determining what is a royalty. But patent office definitely is not the body for that.
Okay. All right. Well, that's
Yeah,
all we have time for. Thank you so much, Sharat. To
sure.
my audience, we have Sharat Sasidharan from Khurana. Khurana, we'll have a banner with your contact information on our podcast.
Sure.
Thank you
Okay.
um, for being on the podcast. And to my audience, until next time, we have our next episode of Unraveling Intellectual Property
Sure.
with Michael Stein.
Thank you, Michael. Thank you so much. Appreciate it.